Hello friends, today let's discuss about agreements in restraint of trade which are void under section 27 of Indian Contract Act. We will discuss about the provision in depth in today's lecture. First and foremost, I'll go forward the introduction and then I will discuss the foundation of the principles enumerated under the provision which were a part of the English common law. Then I will discuss the nature of validity of the agreements which are in restraint of trade. Then I'll discuss the exceptions to the provision and then I'll conclude my lecture. In a free economy, individuals have the right to conduct trade as well as business. But what happens when a contract tries to limit that freedom? The Indian Contract Act guarantees commercial freedom but also recognizes some restrictions. The tension between freedom of trade and contractual limitations form the foundation of Section 27 of Indian Contract Act, which deals with agreements in restraint of trade. First and foremost, what are the essentials of a valid contract? Offer, acceptance, consideration which should be lawful, object which should be lawful, competency of parties, free consent, and the agreements must have not been expressly declared as void. One such agreements which have been expressly declared as void are agreements in restraint of trade. That is Section 27 of Indian Contract Act. The Section 27 of Indian Contract Act states that agreements in restraint of trade are void. Those are the agreements which restrict a person from carrying out his trade, profession or business. Article 19(1)(g) of Indian Constitution provides everyone or every citizen a right to practice their own profession as well as business. So this provision is an extension to the concept enumerated under the Indian Constitution. The principles enshrined under Section 27 have been borrowed from the English common law. Justice, equity, and good conscience are the common law principles. You have to understand complete restraint as well as partial restraint to understand the provision. Let us suppose that you are an employee of a guns and ammunition company. The company puts in a clause in the employment contract saying that you will not practice the same business throughout your lifetime after you leave the company. This is a complete restraint. In the same example, if the company asks you to not practice the same business for a period of 5 years within the same vicinity, then that would amount to partial restraint. Under the English law, partial restraints are permissible. Partial restraints do not make agreements void. But under the Indian law, complete restraints as well as partial restraints make the agreements void. In Northernfelt versus Maxim Nordenfeld Guns and Ammunition Company, Thornton sold his business to a company. He included a clause that Maxim would not engage in the manufacture of guns for 25 years. Along with this, it was stated that he would not compete in any way with the company. The first clause was held to be valid, but the second clause was held to be invalid as it acted as a complete restraint. Along with this, the test of reasonability was born out of this case law. The test of reasonability as follows. The party imposing has a valid interest to protect. To illustrate, let us suppose that there is a doctor by name A and he hires a assistant Dr. B and he shares his client experience as well as techniques with Dr. B. Dr. A includes a clause stating that Dr. B will not open a dental clinic within 3 kilometer radius for a period of 1 year after leaving. This clause will be considered valid because it was meant to protect the reputation of Dr. A as well as to protect and keep the clients intact. When it comes to advocacy and all these things, the advocates learn a lot from the seniors and they had the practice of soliciting the clients. This should stop from happening. So that is why in India, the law firms as well as companies take it very seriously. Even though such things should not be mentioned in the employment contract, they will nevertheless be a part of the contract because at the end of the day, the company's reputation is all which matters. Next, restraint is no more than necessary. A chef sells his restaurant and agrees that I will not open restaurant within 5 kilometers for the next 2 years. This is a valid restraint. Third one, restraint is not against public interest. All three pharmaceutical companies in the city enter into agreement. None of us will sell medicines below 200 rupees. This is a restraint which will be against the public interest. Let me take another illustration. A franchisee agreement where McDonald's franchisee is restricted from opening another fast food outlet within a specific area will be considered a restraint which would not be against public policy. There are things like non-compete clause, meaning during the subsistence of employment period, a person, that is the employee, will not compete with the company and it will not be a situation where the company's employee will start similar business alongside. That should not happen. So that is why non-compete clauses have been introduced in the employment contracts these days. See, non-compete clause should not be there after the company's employee leaves the company. If the compete clause is enumerated in the employment contract before and during the subsistence of the employment period, then that is something which is permissible. The nature of these agreements are that they are void, but they are not illegal. In Mahub Chandar versus Rajkumar Das, an agreement contained a clause stating that the plaintiffs were stopped from practicing the same trade in and around Calcutta. If there are clauses like that, they would be contravening Section 27 of Indian Contract Act. If during the subsistence of employment, an employer puts in a condition saying that the employee would not compete with the company and start similar business alongside the company, then such clauses are valid. Trade combinations. When it comes to Partnership Act, there are sections which state that partners should not start similar business alongside the purpose behind which the partnership firm came into existence. So there are exceptions to the concept of agreements in restraint of trade. I'll be dealing them in a while. And even exclusive dealing agreements and franchisee agreements are permissible and they will not be called as agreements in restraint of trade, as well as arbitration clause. Arbitration clause selects the court of jurisdiction, but it does not lead to any restriction upon a person. That's why our arbitration clause cannot be considered as agreements in restraint of trade. There are exceptions to the provision. The first one is sale of goodwill. Goodwill is nothing but the capacity of a company to retain its own clients, and it deals with reputation and brand value. Along with sale of goodwill, the contract can state that the seller has been restrained from carrying out similar business for a period of time as well as for a particular geographical location. In Chandra versus Prashulla, plaintiff operated fleet of buses between Pune and Mahabaleshwar. Defendant had similar business. Plaintiff bought defendant's business alongside goodwill and by contract made him agree not to open a similar business in the area for 3 years. The defendant nevertheless opened similar business. Plaintiff brought an action against the defendant. It was held by the court that the agreement was valid and it was not in restraint of trade as it fell under the exception to the agreements in restraint of trade. The second exception is partnership. Section 11, Section 36 and Section 54. Let us suppose ABC start a bakery and name ABC Bakers. If we take Section 11, no side business during partnership. That will what will be stated in the partnership deed. And if we take Section 36 Clause 2, post-exit non-compete, meaning if B partner retires from ABC Bakers, he cannot start a similar bakery across the street right away. The partnership deed can state the time limit as well as the geographical limit. Section 54. No competing before dissolution. A, B and C plan to dissolve ABC Bakers. They cannot start another bakery before dissolution is complete. Thus, I would like to conclude by stating that agreements in restraint of trade are void, but there are exceptions. The first one is sale of goodwill, and the second, trade combinations. The Partnership Act induces certain responsibilities towards the partners, like the partners should not compete with each other, they should not open a business alongside the purpose with which the partnership firm came into existence. And along with that, a non-compete clause can contain in employment contracts. During the subsistence of employment, the employer can ask the employees to not compete with them and operate a similar business alongside the company. Arbitration can happen either by a separate agreement or through a clause in a commercial agreement stating that the matter will be referred to arbitration in respect of dispute. These clauses are not agreements in restraint of trade. They are just selecting the jurisdiction. Thank you for listening to my lecture on agreements in restraint of trade.